Welcome to the Ryerson Negotiation Project. Our guest today is Sara, and I hope I pronounced this correctly. Nagalingam?
That's right, yeah.
Sara is a lawyer with the firm of Ryerson and Genova here in Toronto. So welcome to our show, Sara.
Thank you.
Sara is a graduate from two law schools, the Faculty of Law at the University of Ottawa. I believe that's in civil law.
That's right, yeah.
And the Faculty of Law at the University of Windsor, which is a common law. That's quite a distinction to have. I know many, many lawyers, and being one, to have the two distinctions is quite unique.
Yes, yeah. It is a specialized program, so I'm very happy that I ended up doing that program. It gives me the ability to practice in Quebec as well, if I'd like to.
Oh, parlez-vous français?
Oui, je parle
Oh, c'est
français.
bon, c'est bon. Sara has been the recipient of several academic awards, including the Laskin Bilingual Moot Competition and the Hicks Morley Labor and Employment Moot Competition back in 2010 and 2012. Our guest manages a very diverse personal injury practice, and this would include such things as plaintiff side legal actions arising from motor vehicle accidents, slip and fall accidents, long-term care home abuse, private disability denials, Canada Pension Plan denials, as well as criminal injuries. Sara also contributes some of her time as a judge to the Ryerson University Law and Business Student Association. Sara, once again, thank you very much for joining us on the Ryerson Negotiation Project.
Thank you for having me.
Now tell us a little bit about the personal injury type practice. You represent individuals who have been hurt in a motor vehicle accident, or they've fallen at a hotel, or obviously in a bar maybe some night.
Yeah.
What happens in all of that sort of stuff?
Well, we get clients who've experienced all kinds of injuries. You know, the most common one that people think about is motor vehicle accidents. People who were doing what they were supposed to when driving on the road, or maybe as a pedestrian, and they were struck by someone else, have suffered injuries, sometimes minor injuries, but oftentimes when they come to us, their injuries have been quite severe, to the point where they're functionally limited. They're facing barriers in their life now because of their injuries, and that's why they're coming to a lawyer, because they believe that they'll need the compensation to continue with their life, whether that's for medical benefits or for the income that they've lost, various things challenges that they're now facing in their life.
Is the system in Ontario, is there a cap in terms of the compensation which can flow to a plaintiff or an individual who's been involved in a motor vehicle accident?
Yes, there are various caps that apply, and in different cases you have to look to different legislation. I know when you speak with any lawyers who work in the motor vehicle accident realm now, they'll tell you right away that there are things called thresholds and deductibles, and we're at a time with these cases where we're faced with a lot of limits in terms of what plaintiffs can claim, in terms of types of benefits as well as monetary amounts.
So you need to be very conscious of the process, of the goalposts that are involved in that process. But what kind of preparation, excuse me, would you have to do, for instance, if a person was in a motor vehicle accident, not her fault, not his fault, but was in an accident, and you wish to bring a claim against the other side? What kind of preparation would you have to do to get that up off the ground and going?
Well, the first thing that we have to do is really investigation into the circumstances. So a lot of people, when they come to us, really have limited information about what happened. They have their experience, their perspective about what happened, and they give us whatever information they can. It's our job then to go and seek, you know, the rest of the story. In a lot of times with accidents, because the clients that come and see us are so traumatized by the experience, they're unable to tell us some of the crucial details that we need. So sometimes we need to rely, for example, on the police reports, on some of the expert evidence to piece together the story. At that point, we have to think about our client's position and what information we need to reasonably look over everything and advise them about their position if they wanted to commence legal action against the other person involved or other people involved if there are multiple.
I would think that the client in that kind of circumstances is really looking to you for the cue as to whether to sue or not to sue.
Yeah. And
Would I be right in that assessment?
absolutely. Yeah. And, occasionally you do have people who come to you and say, there was wrongdoing and therefore I have a right to sue. Unfortunately, it's not that straightforward. My job involves a lot of teaching or informing, if you will, members of the public who only have a vague idea of some of the limitations that are in place in our justice system, to explain everything and how it works. The fact that something went wrong doesn't necessarily mean that it's the right place or the right time to commence a legal action, although many times it is, and that's why I have the cases that I do.
How key is it to develop that relationship with the client? The client comes into the office, sits before you, tells you the story as to what has happened. But that relationship, solicitor-client, becomes pretty pivotal in terms of success or not success.
Yes, I agree with that. And I think it's important to foster that relationship early on.
What are some of the things you do for that?
Well, it's important to have open communication and in informing the clients early on what to expect. And that can be very difficult because when you're going through a legal action, there are so many steps, there are so many things that could change over time. Unfortunately, I'm not able to tell most clients when I first meet them, this is the definite result we will arrive at. If you commence this legal action, you've got a slam dunk case, or you have a terrible case. So many factors go into evaluating how likely it is that their case is going to be successful. So more than telling them what the result will be, my job is to explain the process and all the factors that will come in and how time might change that.
Do you find yourself having to repeat the process to the client? They come in on a Monday, you outline the process for the particular claim going forward, and then 2 weeks out, they're back into the office. They really forgot certain elements of the process. Do you have to repeat? Do you have to educate, inform, provide insights in terms of that process going forward?
Yes, definitely. When you first meet with a client and you're telling them about the process ahead, understandably, it's a lot to understand and absorb and apply to their own situation, especially when they're dealing with health or medical issues. So I make it a practice to repeat the process and the steps that are upcoming as they come, and just lay out the groundwork for what can be expected so that the clients aren't left in the dark about that.
What is your take as it relates to your communication style with the client? Are you a person that obviously you would have a verbal exchange with the client, but do you write them letters? Do you send them emails? Is it a combination of meetings and emails and letters? Do you bring them into the fold? How would you describe your style of communicating with the client?
I think in my ideal situation where it's possible, I always like to meet face-to-face. There's less chance that there's any miscommunication, that, at that, if you're both in person, if you and your client are both in person, it really helps the relationship, builds trust between you. But unfortunately, given the fact that so many of our clients live all over Ontario, they have to travel quite far distances sometimes to come and see us in person, or we as lawyers have to go out to them. And time restrictions we face, unfortunately, face-to-face meetings aren't always possible. So I do make quite a bit of use of the phone and email to speak with my clients. But I would prefer to at least see the clients in person or speak with them via telephone, and then confirm what I've said in almost summary format in either a letter or an email. And that's more for their benefit than mine. My intention in doing that is, when we're speaking, usually a lot of information is exchanged. And for clients coming out of a conversation, they might think, oh, well, I'm not exactly sure what she said. I want them to be able to quickly look back and be able to remember what it is we've discussed, and also be comfortable in knowing if they see something in that letter or in that email that they're not sure about, they can give me a quick call or write me a quick email back and ask for clarification. I'm happy to do it.
So that's a very unique style. You would have a one-on-one, you would have phone calls to elaborate, and then you'd provide them with a bit of a summary as to what we've discussed, where we're at, and where we're going. Do you find you get many inquiries from the client as a result of that three-step process?
Yes, we do, and I'm happy about that, because I would rather that the clients feel that their concerns and their questions are being addressed. I think if you're only touching base with your client in person on a rare basis, you're really not acting for the client as you should.
So let's talk about another stakeholder in the process, police reports.
Yes.
How do you deal with the police and their reports? What's been your style and mode of operation?
Well, in some cases, the way that the police investigate certain incidents can be very helpful. They are sometimes the first people on the scene. They're able to talk to all the parties involved. Sometimes they take statements. They're able to take photographs, video evidence, all types of evidence that wouldn't otherwise be available. However, a lot of the time, the police are not there when the incident occurs. Like us, they are
After the fact.
They're after the fact. So their evidence might not be as complete as I would like, or as impartial as I would like. As much as they try to be, they also have to. They are only able to gather the information that they have before them. And if everything is not available, then unfortunately they're limited as well.
So what are you entitled to receive in terms of the police report? There's an accident, the police officers are on the scene, and they write up a report and they take pictures. Are you entitled to see all of that?
Sometimes they provide us with information that relates specifically to our client, because our client has given us authorization. But in a lot of cases, when there are multiple parties involved, they do have an obligation due to privacy laws and such to redact a lot of information or withhold some of the information. And they usually tell us when they're doing that and why they're doing it.
Do you ever get a chance to see it?
Well, that really depends on the situation. So in many cases, when we think that they've withheld or redacted information that's crucial to our case and that is relevant, we have to actually make a motion before a judge for that information. And we present our case as to why it's important, and there are certain stipulations that are made by the court about not releasing more information than is necessary for our purpose, and that's how we have to go about getting it.
So who would get all the information?
All the police information?
Yes.
In most cases, we will, unless it contains something that is not relevant to our case. Now, in the instance of an accident, most of it is usually relevant.
But it may not come all at once. You're going to have to pry and ask. So
Yes.
What sort of things do you do to maintain a good relationship with the police and vis-a-vis the police reports?
Well, when we make requests for an unredacted file, the police actually have certain conditions that they want us to abide by. So when we let them know, look, we will be looking to the court for an order to get your unredacted and complete file, they usually list various conditions that they want us to present to the court on their behalf. And we do that. We always do. Courts are so familiar with this situation now They will ask if we've spoken to the police, what their position about this is, whether there's sensitive information and why it needs to be withheld. So we do in that way act on behalf of the police in presenting all the information to the court so that the court can make the appropriate decision and order if they need to.
So do you actually speak to the police officer that has done the investigation?
It depends on, again, on the situation. When we're just looking for the file, a lot of times they have departments that deal with that, with documentation. When there's a police officer that we actually need to question, that often comes in at a later stage. For example, getting a statement from the police officer if they were involved, if we think there was a problem with something that's been written in the file or documented a certain way, if we think it contains incorrect facts, that's when we might need to speak to the police officer directly.
And tell us about the experts that you may or may not have in a particular case. I'm involved in a car accident, you're representing me, I have a bad lower back, I think I should be able to sue the other side because I'm in great pain and it looks like I'm going to be like this for quite a period of time. But we need an expert to say that I do have lower pain. What do you do in those kinds of instances? Would you write to the expert, speak with the expert? How does it work?
Yeah, that's generally how we go about it. And you know, we can use various types of experts, but medical experts are, you know, those that we rely on quite a bit, especially because, you know, when a client has a certain particular type of injury, we have to not only be able to figure out exactly what's wrong, but also the causes of that injury, how that injury might improve or deteriorate in the future, what kind of care might be necessary. These are the types of things that experts can opine on that can really assist our case and give both sides a clearer picture of what we're trying to achieve, especially because in personal injury cases, there are so many different things that we are asking the opposing side to consider and to compensate. Pain and suffering, income loss.
Oh, I've had a lot of pain.
Yeah, well,
I want more money. I want more money.
Pain and suffering is such a difficult thing to quantify, and that's exactly what we're trying to do in our line of work. So it helps to have you know, case law that helps kind of guide us, but it also helps to have experts to give us an idea of, like I said, the severity of the injury, the prognosis, future care needs.
I don't want to get into the specifics of the law, but perhaps you could shed a little bit of light. Is the expert that you would have, would they be making a submission to the court, or would they be making a submission to you so that you can make to the court? In other words, where's the consideration for the expert?
Well, in a lot of cases, again, it depends on the situation, but in a lot of cases, they're writing expert reports that are presented. If you do proceed to trial, then they can be used. Their reports can be used. And those doctors in certain circumstances can be witnesses who are cross-examined, et cetera. But the majority of the time, they are giving their opinions in writing and preparing themselves for questioning or things like that in the future.
Would the other side normally have an expert as well?
They would. They almost always do. And it depends. The experts that are retained really depend on the type of issue you're facing.
It's a lower back versus a broken ankle or a broken nose.
Exactly. And there are so many people, when they think of injuries, often only think of physical injuries, you know, having a broken bone. But there are other types of injuries that come into play.
Such as?
Chronic pain cases are becoming more relevant now, or more discussed now, I should say. It's always been a difficult case when someone has an injury, and while in certain situations that injury is expected to heal and the person should be good as new and have no functional limitations, sometimes that doesn't happen. Sometimes it deteriorates, the pain is prolonged, their functional limitations are prolonged. And in some circumstances, you'll encounter a situation where, you know, experts, doctors take a look at the situation and say, unfortunately, no matter what kind of care you get, what kind of medication, what kind of surgery you get, you will never return to your pre-accident level.
Boy, that's a difficult message to give to a client, is it not?
It's difficult to give that message, and it's difficult for our clients to receive that kind of message. And that's what can be sometimes the hardest part of my job, is to know that although we are trying to help with the expenses and the challenges that they're facing with their new lowered level of health or condition that they now have to live with, money will never restore their health. That's unfortunately something that I can't do. So I do the best I can with monetary compensation.
Share with us, if you can, in terms of you having the client and the mandate that you get from the client. Is that always clear from the client, or do you have to do some digging and a lot of questions to get the mandate in order to proceed?
Most of the time I have a discussion with the client early on about what they are looking to achieve and what the limitations of the legal process are. Like I said, a lot of people feel that when they are wronged, when they are injured, they are deserving of compensation for reasons that the civil system does not compensate them for. For example, some people think, I want to be compensated because someone did something wrong and they should learn from their mistake. Unfortunately, that's not the purpose of our system. Our system is compensatory. We are looking to put them in the position they would be in but for this accident. So I sometimes have to repeat that because it's such an emotional process. Sometimes clients can lose sight of what their goal is or what they're trying to achieve by going through the legal process, and I have to remind them occasionally. So.
I have found, even in my own practice, which is corporate commercial and some dispute resolution, that I have found that the retainer letter
Yes.
is an important document. But I find that it's becoming more and more complicated in terms of that retainer document.
Yeah.
Because the client will refer to it, yes, it's your fees and it's your expenses and all of that, but in terms of the mandate going forward, do you try to put the mandate that you get from the client into the retainer letter? Or is it sort of, yes, it's in the retainer letter, but it evolves over a period of time? Because you can't put everything in the retainer letter.
Yeah, I would say that usually it evolves over time. The retainer letter, again, is something that we go over with the client, usually in the initial stages of a process. And while at the time they may think one way, over time, over involvement in the process, while their health or condition changes, perhaps as they have more interactions with the opposing side, things change in their mind. So it's really an ongoing relationship and an ongoing discussion that we have with clients to figure out what their goals are, where we're headed, and how we're going to get there.
Tell us, if you will, about trust. Trust is pretty important aspect of negotiations, but in dealing with human behavior, are there certain things that you do with your clients and with others in order to give the trustworthiness that is part of your reputation, that you want to make sure that the client understands that you'd like to do this, but you really can't because the law precludes you? What are some of the things that you do in terms of developing this trustworthy behavior?
Well, I think the only way that you can really earn trust with clients and with other people you deal with, opposing lawyers, for example, or insurance representatives, the only way to really do that is to mean what you say and say what you mean. And what I mean by that is when you're telling clients that you're going to take a particular course of action, taking it. So letting them know that you're going to update them at certain intervals, following through, but also because of the uncertainty in the process, advising them when you're not able to give them a definite answer. I would love if I could give a definite answer to all the questions I'm asked. Unfortunately, a lot of the process is, is influenced by other players. So I think by being honest and explaining to them the extent of my knowledge or my ability to assist them in a certain area, and then letting them know about the risks involved, the things that are out of our control or that might be influenced by another party. And over time, if you have continuous communication, honest communication, I think the trust will build.
Tell us about dealing with the other side, the other lawyer. How's that?
Well, sometimes it's a great experience and sometimes it's a less than great experience, but it's part of being a lawyer, and it's part of being a negotiator. Sometimes you see eye to eye, but very rarely. You're always in a situation where you're going to disagree on some issues, but I think the important part is how you deal with it. I think the most important thing that I try to keep in mind is always to treat others with courtesy and civility. In our practice, sometimes when you disagree on things, you lose sight of how you should conduct yourself, and I don't think that's ever appropriate. I think that it's important to conduct yourself in a civil manner, respectful manner, even if you disagree.
How do you handle the situation where the lawyer on the other side is very, very passionate? I think our viewing audience would say passionate. What do you mean by passionate? Someone who really believes in their case and they think that you're wrong, that you're falsifying facts, that that's not really what happened, and they have a particular take, and they're just being so dogged, determined that they want to see their side of the facts being revealed. How do you deal with those kinds of individuals?
Well, I think that lawyers who have been in the practice for some time understand that while we're all passionate and we're all trying to work towards working for the best interests of our clients, it's never a good idea to think that your position is the only position. It's important to be open-minded, to be reasonable, and even if you don't agree, to be open to listening to other perspectives. When I encounter a lawyer who is inflexible, I do what I can to explain to them why I think being flexible is important. Negotiations, especially in our profession, always involve some kind of compromise on both sides. And so if I'm engaging in negotiation with someone, it's important for me to know that they are being flexible and making concessions on their side, just as I am and just as I would. That's what I would say.
Tell us, if you will, in terms of that relationship, yourself and the other side. I mean, you're a young lawyer. You're going to be at the bar for a number of years practicing, and your reputation is probably one of your biggest assets.
Yes.
You need to protect that.
Yes.
Have you encountered people on the other side that want to take cheap shots, whether it's in letters, whether it's in communications with the police, whether it's in communications to the court, that are saying things that are not 100% on the mark?
Yes, I have encountered situations like that, and
you don't have to give us names, but
no, but I think it's important to always maintain your standard of integrity and honesty, even if the opposing lawyer is not doing the same. I always think of, I think it was my first day of law school, and our dean said to us, you're sitting amongst all of your classmates at that point. Look to your right, look to your left. And instead of saying, what people think he's going to say, he said, these are your colleagues, not just your classmates, and they will be for the remainder of your career. And that really rings true. I think to myself, looking back at that time, we work in a very small community of lawyers. It seems big in Toronto, but we really have so many people that we encounter time and time again, and your reputation is everything. The way that you conduct yourself is very important, and it's important to be honest and reasonable and civil. When I don't encounter those things, I think it's too bad. I have to deal with it for that particular situation. But it is more difficult to build a good reputation that way.